So your injury lawyer calls you up and says, hey, we got to go to mediation on your injury case. And you're like, great, I think. What is mediation? Would you like to know more? Well, come join me as we talk about the ins and outs of mediation in your injury case. And I thought we could do it in a little walk and talk format here in the beautiful foothills of San Diego. This little hiking path is called Hollenbeck. It's where the sycamore and oak trees are among us. Hello and welcome. So I'm San Diego personal injury attorney Mark Blane, practicing law here in San Diego, California. And so we're talking about mediation. What is it? Well, mediation is a time in your case, your injury case, where you have a chance to see if the other side and your side can meet for a settlement to settle your injury case. Sometimes it's court ordered, sometimes it's voluntary. Just depends on certain factors and the case. So how is it going to affect your case? Well, in certain regards, it can affect in different ways. First of all, why is mediation even being set up? Why can't we just negotiate it and the other side and be done with this? Well, there could be factors in your case that dictate that a mediation is amenable, meaning that it's a welcome exchange to see if the case will settle effectively or efficiently. Now, sometimes, not always, you might have a lawsuit against other defendants. So you'll have multiple defendants and they're fighting each other saying, hey, we're not liable for this, we're not liable for that. We're only liable for certain aspects of what happened to you. I had a case not too long ago. It was a defective ladder case, and we had like 6 different defendants. Property owners upon property owners, right? They couldn't figure out which excess policy would apply, after we get to a certain stage in the case. So that became really difficult. So we actually had to go to mediation to see about that. We didn't settle it in mediation. It was so confusing that the defendants had to do their own mediation to figure out who's going to pay what after a certain amount pays out a certain excess policy for the client. So in that regard, mediation was very effective. It was an efficient way to get the case to a meaningful resolution for the client and for the other side. So in that regard, you'll find that mediation is quite effective. Let's say the other side offers mediation or it's ordered by the judge. Does that mean that I'm going to blindly go to mediation? No, not without certain parameters. Sometimes mediation won't be effective in certain cases. For example, if an injury case is worth $100,000 and the policy limits are only $100,000 from the at-fault party, then a mediation won't be amenable, meaning that it wouldn't be effective. Either they pay the policy or we go to trial. So that's one example where you wouldn't have it or it wouldn't really work that well. But again, it's something that you can consider. And when I do it, I always lay down parameters with the other side, meaning that if we're going to agree to it, and my client has to be there, of course, your client has to be there as well. And I do that through what's called a letter, and I make it confirmed. That way, if there's any problems later as to why the mediation didn't occur, we have a nice foundation of evidence for the judge to know, hey, there was no cooperation from the other side because of this or that. So it's something I do, and sometimes I make the other side put up a certain dollar amount so we know that they're serious and that they're not just putting on a sham and they're serious about selling the case. So that's another parameter I put on the case so it protects my client's interest. Now, it depends on the certain type of case that it is, but again, it's something that can be done, something that should be considered, and see if it makes a difference in terms of being serious and seeing if we can get the case settled. Now, mediation itself is all about control. And so you want to be able to control and know the roles of each party in the mediation. In the mediation itself, my client will be there, defense attorney, and I do require the defendant to be there, because if my client's taking time out of his or her day to see if the case can be settled, well, the other side should do the same. It's only fair. So I require that. And then there's a mediator, usually a retired judge or an attorney that just specializes in doing this, who probably had or does have prior trial experience. And so those are mediators, the neutral third parties. Now, if the case goes to trial, does the jury get to hear about the mediation and the attempt to try to settle the case? No, they don't. It's totally confidential. And if my client agrees to settlement, it's voluntarily done. And that's something that we consult during the mediation. Mediation can take all day, take several days. In the other case, it was several mediations over several weeks before the case actually settled. So depending on what kind of case you have with the injuries and whatnot, it could take that long, or it could take just a couple hours if it's a smaller case. It's an effective way to get things done. There's strategy to it, and you got to be with a lawyer that knows the ins and outs of what the defense likes to do. And like I said earlier, tries to put up a sham defense or a sham effort and say, yeah, we'll go to mediation, but they're not offering any money when we get in there, you know? So we'll make them put up a minimum dollar amount if I sense that's going on. It's a skill that you develop over many years of just doing this for, you know, practicing law. And so it's something that you should know, you should be aware of, especially if you have a case with an injury lawyer here in California. Now, you're probably wondering, why am I sharing you this information? Well, number one, you might be in a situation with your injury case. Maybe you don't have one filed yet, and you're thinking that you might have one, or you just need more help on mediation and what it's all about. I invite you, pick up the phone, give me a call. More than happy to discuss anything about mediations in your injury case. My telephone number is 619-813-7955. My email is Mark with a K at BlaneLaw.com. That's B as in Bravo, LANE, LAW.com. So that's it for the video. Hope that was helpful. Have a great day. Hi guys, thanks for joining me on this great little walk in the woods here in Hollenbeck Canyon. Just want to say I had a great time making that video for you. And remember, I'm here for you on anything. I've got free information downloads, ebook, injury guides, survival guides for any particular injury in California. So if you need a free copy of that, just head on over to BlaneLaw.com. That's www.BlaneLaw.com. And here's one as an example, 10 Secrets book. I got a few other ones, so take your pick. And again, I'm here if you need me for anything. And that's it for the video. All right, well, I hope you have a great day. Thank you so much. Bye-bye.